Hi everyone, this is the third video on pre-termination negotiations and confidential settlement discussions. We've looked at setting the scene so far, we've looked at how long we might need to give an employee to consider an offer, and also the role of a representative potentially for the employee in those discussions. We're now going to just pick up on the point of admissibility, and by way of background, one of the main selling points for bringing in section 111A, which covers off these confidential settlement discussions, is that if they are conducted reasonably and fairly by the employee may not rely on the content of those discussions in any future proceedings. So this was all designed to give some comfort to an employer that they could hold a discussion that would remain confidential if there was any future employment tribunal claim that was brought by an employee if those talks broke down. That is not always the case, however. So when this section was brought into the Employment Rights Act, it was made clear that this only applied to ordinary unfair dismissal proceedings. So if, for example, we were looking at performance managing an employee and as an alternative to starting a process which could end in a performance-based dismissal, we had this discussion. Ideally, the section of the legislation would allow us to hold a confidential discussion that wouldn't be applicable if we went to the extent of dismissing and an employee claimed. Those negotiations can be treated as confidential even where there is no existing employment dispute. So prior to this legislation coming in, the traditional without prejudice rule required there to be some sort of dispute that was being compromised in order to have the protection of these discussions being confidential. There are some exceptions to this admissibility rule though, and firstly, automatic unfair dismissal claims are not covered. So if, for example, we have a discussion with an employee who is pregnant with a view to settling their employment, they reject that proposal, they're ultimately dismissed and bring a claim alleging that the only reason they were dismissed was because of their pregnancy. That is an automatic unfair dismissal claim. It's one of the automatic unfair reasons in the Employment Rights Act, and the employer would lose the protection of the without prejudice rule in those circumstances, and those conversations would be admissible. Importantly as well, discrimination claims are not covered by section 111A of the Employment Rights Act, and that brings us on to quite a tricky technicality really at the point of having the discussion. So the employer needs to more or less predict what the employee may have claims in, or the claims that the employer may potentially be able to bring, in order to guess whether or not the without prejudice protection is going to apply. So if the employer has not identified any protected characteristics such as sex, race, age, disability that may found a discrimination complaint, and they are confident that we are just looking at a potential unfair dismissal liability if these discussions are unsuccessful, there will be some confidence that those conversations remain inadmissible. But if, for example, we have a performance management issue, we want to have a without prejudice conversation with the employee, and during that discussion they say, well, the only reason I'm underperforming is because I'm disabled and that disability is causing me to perform poorly. If ultimately those talks break down, we dismiss, the employee brings an unfair dismissal and a discrimination complaint, at that point the discussions become admissible. So it is something to consider at the outset when we're looking at whether to have this discussion or not, and whether we absolutely need the confidentiality protection to apply. We need to be thinking what claims are in contemplation and are we going to benefit from that admissibility rule. What I would flag, however, is that the approach to that discussion is crucial. It's not necessarily the case that just because that conversation is admissible, the employer is going to automatically lose a claim. What it does mean, though, is that the tribunal will examine how that discussion was undertaken and whether any unfair practices or improper behaviour was applied. And that's why I think if we are willing to take the risk that those discussions may be admissible, get the process right. So be very reasonable with the employee in terms of setting the framework for that discussion, not making any threats, not putting undue pressure on the employee, giving them a reasonable period of time to consider the offer, allowing counter offers, setting the scene properly for that discussion, and making it clear that if they do reject the offer, it will have no bearing on any future process. So that does explore the limits of the admissibility and confidentiality protection that is available under this section. But I think it's more important to get the process right so that if those discussions are referred to, the employer can defend the position. We're going to move on in the final part of the video to discussing improper behaviour and case law examples of where tribunals have found that the employer has lost the benefit of confidentiality protection because of some action that they've taken during those discussions. In the meantime, if you do need any assistance on this topic or anything employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.